issues tonight. Tonight we were talking all about injuries. So if you have a call, I say that every week. If you have a question, give us a call, 850-392-1544, or you can email us that question at lawcall@WMBB.com. And tonight I'm actually joined by my good friend. I heard he was the third, but I actually think he's the second most eligible bachelor in all of Bay County. Maybe even the first. Ladies, the Brian Connors. Brian, how you doing, bud?
I'm not happy that you said anything right now, but as Les said, we are taking your questions tonight. If you have calls, not calls if you have questions.
I seriously, I do that every time I host the show. Every single time I say, if you've got a call, give us a question. Whatever. I should read teleprompters more. Again, we're talking all about injuries. If you have a question, give us a call. The phone lines are open, or you can shoot us that email if you're a little shy to go on TV and appear in front of a live audience out there. Not here, but out there. We'd love to talk to you. So again, phones are open. Brian, injuries. We do personal injury law. Most of the time it's car wrecks, sometimes medical malpractice, sometimes slip and falls. There's a whole wide variety of injuries. But usually the first thing that I get asked is, do I have a case, number one, and how much is it going to cost me? I mean, it seems pretty basic, but that's a lot of times I got hit. Do I have a case? Or I fell. Do I have a case? How much is it going to cost me?
I think everybody always asks me, do I have a case, or are you going to take my case? And for us, 99% of the times, with the exception of like dog bites, but if somebody does something wrong and you are injured, then you have a case.
Right.
Now, what we're able to do for you in that situation, it really depends. Can depend on insurance, facts, evidence, when you tell us how long it's been. Because sometimes people wait too long because they're scared to have to pay an attorney to do a consultation or something like that. And if you wait too long, sometimes that can jeopardize your case and prevent us from taking it.
Right.
But for us, we work on a contingency fee. So you don't pay any money for consultation, or you don't really pay us until we actually get a result. So if there's a settlement or we go to a jury trial, that's when our fee triggers. That's the contingency. And our fee is we charge what everybody else charges. It's 33 1/3%. If we resolve your case without a lawsuit being filed, if we file a lawsuit, it does go up to 40%, and then we take out our expenses as well. But most of the time, that's people's main concern. They think they're going to pay thousands of dollars up front,
right,
and they're scared to do that. And it's better to just have a consultation at a minimum. Sometimes you have a case, sometimes you don't.
Right. A lot of people, they say, well, why a third? I mean, and really it varies by state. I mean, some states, if you go up across the state line up in Alabama, I believe they allow them to charge really whatever they want to negotiate. I'm admitted to practice up in Georgia. I know the standard fees up there can be a little bit higher, up to 40–45%. Florida, ours is set by the Florida Bar as what is considered a reasonable fee, and that's that 1/3 number. And it does seem like a pretty high percentage if you think about it. Wow, that's a third of the overall recovery. But what most people don't realize is that when you get an attorney that understands the law, that understands personal injury, the vast majority of the time, and there's even Insurance Institute studies out there that have proven statistically that attorney-represented claims typically will garner 3 to 5 times more in a recovery than what a person would be able to do on their own. And so, if you think about it in those terms, you're paying the attorney, but you're actually doing better than you would had you tried to go it by yourself.
And the big thing is you know what you're doing. We're explaining what your options are. There's times out there where somebody settles a case very quickly and they jeopardize another insurance claim with another insurance company they don't know about, or their own insurance company. So just having a lawyer, we can answer all your questions, make sure nothing bad happens. I say that as though, if you don't know what your bills are, if you don't realize, Medicare paid $5 grand towards your medical treatment, you settle your case, you have to pay Medicare back. It's things like that that people just don't know,
right,
when they're injured and accept money, and can come back to bite them.
Yeah, if you don't protect those liens out there, there's federal law, state law, contractual obligations. If you don't satisfy those, you may make a recovery, but if you do it by yourself, you may be on the receiving end of a lawsuit by one of those entities if you prejudice their right to get their money back, which is set by statute. We actually have a call. Dan from Bay County is calling in. Dan, go ahead with your question. Go ahead, Dan.
Hello?
Hey, Dan.
Yeah, thanks for taking my call.
Yes, sir.
Question, you have a piece of property that's posted, no trespassing. Someone goes on it without your knowledge, goes on it and gets hurt. Can you be liable?
Dan, that's a fantastic question. I mean, it really is. I mean, because people oftentimes think that if I put a sign up, no trespassing, or if I put a sign up, beware of dog, does that absolve me from liability? And you know, in true lawyer fashion, the answer is going to be it depends. Now, I know, Brian, if I put up a no trespassing sign and somebody trespasses, there are still ways that you could be held liable, but it's pretty hard. And what's the difference between somebody that's invited on your property or somebody that's allowed to be on your property? Say it's a utility worker and they're there to work on the, you know, the cable line or the water line going in, versus a trespasser. I mean, what are the different duties that a landowner owes to those different classifications of people?
Yeah, and technically there's one in the middle called a licensee, but we'll ignore that because it's basically the same thing as a trespasser. So if I invite Les on my property, I got to make sure my property is safe and that anything that's dangerous, I've corrected it or put warning signs out. But if you're trespassing, for a landowner to be held accountable, you have to either do something where you know someone is going to be injured. For instance, I mean, this is a crazy example, but if you have a landmine on your property and a kid walks on it and blows up, that's a terrible example. You know someone's going to get hurt. If the kid's trespassing, in that situation, you can be found liable. And ignoring stand your ground laws, if somebody's walking across your yard and you intentionally hurt them and there's no threat to you, then you can be held responsible. But it's a much higher burden for that person who's injured to pursue somebody if they were trespassing. Most of the time, I mean, in those situations, there's almost nothing we can do because most people aren't intentionally hurting somebody, they're getting hurt in a negligent fashion.
Right.
And if you're trespassing, you do potentially have a claim, but probably not. The defenses are too strong.
Right. I remember when I was in law school back in the mid 90s, I'm dating myself here. I remember cases like this, and they were talking about essentially if you set a trap. You can't set traps. Okay. You can't do something that that will knowingly injure somebody. Just because you don't like somebody cutting through your backyard, you go and you put some nails or something sticking up underneath. You're not supposed to. You can't do that. I do believe that the person that is trespassing, if they are injured, you would have to look at their conduct. You'd also have to look and see, did they have any fault themselves? I mean, did they, go, oh, I'm going to go get on that property and go climb that tree, and then they fall off the tree? Were they comparatively at fault? Even if you're on somebody else's land, if you contribute to your injury, and the way the law works is the defendant will be allowed to say, well, wait a minute, you bear some responsibility in this case, and a jury can decide whether or not you bear a percentage of which. And now with the new laws in Florida, regardless if you are involved in a case and you're claiming negligence on the other side, if you're found to be more at fault than they are, 51% at fault or more, then now you're completely barred. You have no claim whatsoever. It used to be comparative fault in Florida. You could be 95% at fault and you could sue for the 5%, but now if you're more than 51% at fault, you have no recovery.
And yeah, it hasn't really changed too much how we evaluate cases, but if it's clear that, somebody contacts us and there's a lot of fault on them, we used to be able to take the case if somebody else did something wrong, even though there was a contribution. But now, if there is significant comparative fault, then it's harder for us to do anything.
Yeah, the most difficult cases are the he said, she saids.
The red light.
The red light. I had the green light. No, I had the green light, and you have
with no witnesses.
And you have no independent witness, and it's one word against the other. Or the premise liability case where you slip and fall, you trip and fall. Most people, I did defense work before I started doing plaintiff's work, and so I've tried cases on both sides of the bench here. Look, hey, you should have been watching where you're going. That is a really effective argument for a defendant if somebody trips over something that appears to be open and obvious. That's not really what the law says. The law says you're supposed to maintain your premises in a safe condition. You're supposed to warn people of any dangers, and you're supposed to make efforts to correct those hazards so that people don't get hurt. And the duties are separate and independent. The duty to warn, the duty to maintain, and the duty to what's the third one?
No, just to fix once you're aware of something.
Thank you.
So we always run in. We say slip and fall cases in med-mal, but slip and fall cases are some of the toughest cases for us to handle because we have to prove, if it's a big retail store, that they're aware of a dangerous condition.
Right.
So sometimes, You know, if an employee walks by a puddle of water 4 times, that's easy. They are aware of the slipping hazard and they ignored it. But sometimes, you know, if you're a customer in a store, you knock a water bottle over and then another customer 2 minutes later slips on it. In that situation, the grocery store didn't do anything wrong. I mean,
well, it's hard to say they did anything wrong because they didn't have an opportunity to fix it. But that leads to a great point. You know, we talk about when should I contact an attorney. Oftentimes when people are involved in a wreck or they're injured or they've had a tragic loss in their family, a loved one is seriously injured or God forbid killed, the last thing that's on their mind is, oh, I need to call a lawyer. In reality, you know, maybe there's a family friend, maybe there's another family member that might be thinking about things a little bit differently. That's actually when you should call a lawyer, because the last thing you want to be thinking about after you've been injured or you're taking care of a loved one that's been injured is, oh, I need to preserve that video. Oh, I need to send an evidence preservation letter to that retailer so the video that shows me slipping and falling on this substance on the floor doesn't disappear, because it'll get recorded over after a week. You know, there's all sorts of things that we do on the front end so that when it is time to make the claim, the evidence has been protected, witnesses have been located, we have the set of facts and evidence that we can work with on the claim, versus coming in weeks or months after the fact. It's much, much more difficult to do it then. So yeah, don't feel ashamed or shy about contacting an attorney right afterwards. We actually can really help out, and it usually bodes much better for your case if you get us involved early. So Dan, I appreciate the call. I know we talked around it a lot, but thanks for calling in. Anybody else that wants to call in, the phone lines are open, 850-392-1544. Email lawcall@wmbb.com. We're going to take our first break. We'll be back in a few minutes. Hey, thanks for staying with us. Again, this is Law Call. We're taking your calls live on the air. So if you have a question, give us a call, 850-392-1544, or email us at lawcall@wmbb.com. For those out there in the digital world, if you want to stream us live on Facebook, you can do that too. I mean, that's when people go out of town, I always say make sure that you tune in to Law Call on Sunday nights at 10:30 on Facebook. That way you can see us all over the world.
We're worldwide, is what you're saying.
We're worldwide. We got an email that came in over the break. Let's go ahead and put that up. Okay, this says, I hurt my back at my cousin's house because of loose boards on his back porch. His family is not wealthy, and I don't want to sue him or anything, but I can't afford my medical bills. How should I handle this situation? That's from Sam. Hey, Sam, that's a good question. I mean, I know a lot of times people say, well, I don't want to hurt anybody, but I've got these bills. I can't afford them, or I've got a giant deductible on my health insurance, and so I'm having to come out of pocket. what are my options? And there's actually a couple of them between claims and insurance benefits. So why don't you go ahead and walk Sam through what he can do?
Correct. So the big thing, we always look for insurance first. We don't, generally speaking, we don't sue people to try to get money out of their own pocket. We're suing people because people buy insurance because sometimes these types of things happen. In that situation, if I get hurt at Les's house and I sued him, his insurance company is coming in and defending him, paying any claims that are made. But on property, there's two types of coverages that are applicable. One, it doesn't really matter what happened. It's called medical payments coverage. Most homeowners policies have these types of benefits. A lot of businesses do. Some are self-insured, so they don't. But medical payments benefits basically say there's a cap. It's either $1, $3, $5, or $10,000. If you're hurt on their property, then you just submit medical bills. They'll pay them or reimburse you. That is no-fault coverage essentially. And if it's a minor incident where you go to urgent care or go to physical therapy for a couple weeks, then they're going to pay all your bills and you're fine. If it's more serious, or you have, I don't know the back injury, but back injuries can be pretty significant. Right. If your cousin has homeowners insurance, there's something called general liability coverage where if they were aware of this dangerous condition with the boards and didn't warn you or, fix them, then you have a claim against the insurance company. Now, we do run into situations where insurance companies deny claims and we have to file a lawsuit. Right. So there's always the chance you're filing a lawsuit against your cousin, but when that happens, if they have homeowners insurance, the insurance company hires an attorney. Right. And so that's why people have insurance, and I tell my clients that all the time because our clients hate opening up claims on their own insurance when they're not at fault. Right. But that is why you pay your premiums. That's why the person who's responsible pays their premiums, because sometimes people mess up and hurt somebody, and that's what the insurance is for.
Right, and it kind of goes back to something we talked about earlier in the show when Dan called in. Comparative fault is going to be an issue in this situation. You're talking about your cousin's house and loose boards. One of the reasons why an insurance company might end up denying the claim is because they think you bear responsibility, or you may bear all the responsibility for it, and then it gets into a factual analysis. So you might expect to get questions in a deposition like, well, how many times had you been there before?
No, that's the big thing.
And how many times, is this the first time you ever walked on this? Have you seen these loose boards before? If this is the first time, brand new, you walk out, you step, the board's rotted, your foot goes through, okay, that's one thing. If it's man, when are you going to fix these crappy boards that have been, warped and everything for the last 5 years that you've known about? That's going to be a pretty difficult sell for a jury because they're going to say, well, wait a minute, you knew about it, so why'd you walk on it? And again, that is those simple, common sense type defenses, just like on the plaintiff side, the very simple, common sense allegations are the ones that seem to resonate because we all can kind of sit there and go,
that makes
all right,
sense.
Yeah, that makes sense, versus, I'm going to dazzle you with a bunch of big legal jargon, and then you're going to sit there and go, what did he just say? Oh, wait, you saw it. It was open and obvious. So, it's very fact dependent on a lot of those types of cases. But yeah, there are ways that you could look to where it potentially wouldn't cost your cousin or family members anything. You would just have to understand that if you did file a lawsuit, you would have to name the individual, not the insurance company. Florida law does not allow you to sue somebody else's insurance company. You can sue your own insurance company because you have a contract with them and it's a breach of contract case. But I cannot, if I get in a wreck with Brian, I can't sue Brian's insurance company. I have to sue Brian. And then Brian's insurance company steps in, hires him a lawyer, pays for the defense, pays my damages up to his policy limits, whatever those may be.
And that's not the same in every state. I know sometimes we do handle cases outside the state of Florida. Right. And sometimes you are able to sue the at-fault party and their insurance company. So in Florida, there's a bunch of rules about what a jury can hear. If you say the word insurance, it can cause a mistrial.
It could potentially result in a mistrial.
Where whether or not somebody has insurance shouldn't decide the value of your claim or what a jury could award you. That's why. But they also want to know who's paying. Because if you have, my grandma who, causes a wreck, everybody's looking at her like she's going to have to pay tens of thousands of dollars, and juries might be hesitant to do that. Sure. So that's part of our calculation when we're figuring out who to pursue sometimes. It's better if we can sue an insurance company like my own insurance company or a corporation to where juries don't really bat an eye at awarding something significant when somebody's hurt very bad.
Right. Let's talk about something fun. Everybody's talking about the weather that's coming up these next few days.
Oh my Lanta.
And I got news today that I'm not going to be driving over to Tallahassee on Tuesday for my son's basketball game against Leon, and I'm a little bit broke up about that. However, there's a good reason for that, and that's because they believe the roads are going to be icy, that we're going to get some rain. The weather has the potential to freeze the water on the road, creating very, very slick and hazardous conditions.
Which Floridians are not.
Which we are notorious for being absolute idiots when you're driving on a frozen road. That's just not what we do. That being said, I do expect there's probably going to be, if people decide to get out on the road and they run the risk, you could very well end up going off the road, injuring yourself in actually just going off the road, or getting involved in a wreck if you're not too careful, not knowing how to drive in slick conditions. Is it a defense? If somebody says, well, it wasn't my fault, I'm driving down the road, next thing I know, I'm spinning around and I hit this other car, and they want to blame the weather. Can they do that?
So to paint it in a perspective that Floridians are used to, yeah, the speed limit might be, 45 or 55 on Back Beach, but when it's raining cats and dogs, you probably shouldn't be going the speed limit or a couple miles over like everybody kind of does. You have to adjust your driving to the weather conditions.
Right.
So of course it is an excuse, but if you haven't watched the news or the weather or been on the internet at all, then maybe you don't know it's going to be freezing. But given that it's all over social media everywhere, pretty much everybody who's going to be driving over the next few days should be aware that there's a possibility of very slick roads, so you need to adjust your driving.
Right. I don't need it. I don't need the internet to tell me it's freezing. It's freezing outside right now. We're going to take our last break of the show. We'll be back in just a couple minutes. All right, welcome back. We actually did get another call during the break. Let's go ahead and caller, go ahead with your question.
Yeah, I'm just wondering what the law is in Florida. If you own a commercial building, how much law is required of insurance to carry?
Okay. I don't believe there's any set. I know some industries require certain amounts of coverage, like the trucking industry, for example. There's a interstate requirement. There's intrastate requirements to have a certain amount of security. But for businesses, like a retail shop or hardware store, just some mom and pop business, I don't know that there is any requirement.
Not for the general liability, but if you took out a loan for the building, then you're going to have some sort of insurance in case a hurricane or something comes. But that would be something between you and the lender that they work out. But with respect to general liability, you can be what we call self-insured and not have general liability insurance, But if something, significant happens, you could be paying out of your own pocket.
Yeah,
It costs you a lot of money.
It depends. It's insurance is a risk analysis more than anything else. You're engaged in a business. What are the risks associated with your business? Do you have people coming in the store all the time or not? Are you working out of your house? Do you have a fleet of vehicles or not? Or are you doing drop ship for things? Those specific activities would really dictate whether or not it would be prudent for you to have insurance, but I'm not aware of any laws out there that say you have to have a specific minimum amount. It's whatever your risk tolerance would be, and I would just encourage you to get with a local agent, somebody that writes insurance for the type of business you have. Get with them, talk about what your concerns are, and I'm sure they can set you up with a good policy to protect you.
Okay.
All right, Richard, thanks for that call. All right, we're shout out time.
Are we doing photos or are we doing shout outs
We got a bunch
first?
of photos.
Which one first?
All right, so there's Larry and some folks. I'm not sure who that is, but Larry sent in like 11 photos. So we're going to go through these. There's Larry and some nice folks here in Bay County. That's Terry Cole and a grandbaby and his granddaughter. How about that? Terry Cole with of the WMBB with his granddaughter, and he's retired, and he's playing Candy Crush. Okay. Let's see.
That's Pam.
That's Miss Pam. Yes, ma'am. That's Larry's lovely wife. Who else we got? There's Larry and a nice gentleman as well. Larry looking sharp and dapper in his sport coat.
Larry was just taking pictures all week.
Selfies with Larry. There's some more. That looks like Judge Mooneyham back there. Okay, all right. There we go. And keep going. Gosh, my eyesight's so bad. There's Larry and Pam, and I wish he'd have given us the names of all these folks.
Larry gave us zero heads up. But Larry took a picture with everybody in Bay County.
Okay, next one's. There's Larry again. Selfies with Larry.
I was with Larry.
Oh, it's at the hospital.
We were at the hospital on Friday seeing somebody.
Okay, all right.
That same gentleman recognized us when we came in.
Okay, there we go.
There's
Mr.
G
Gary
Money.
Starr.
G Money.
The Gary Starr, G Money.
Right,
I was going to give him a shout out.
One off my shout outs right
Okay.
there.
And Edward the officer with selfies with Larry. Okay.
All right, we're going to have to burn through these last couple.
All right.
All right, I'll go first. Shout out to, of course, April and Brian. I love you guys. Captain Brad, Ben has been blowing me up. Miss Pam, Lois, and Otis. Jimmy watches every time. Marvis, G Money, Captain Trav, Rachel, Harriet and King, Ray, Rick from the Marlin, and Bruce and Donna. Go.
Wow, okay. Miss Pam, again, my mom and dad, my lovely wife Jen, daughter Rachel, and son Eli.
Jen's lovely right now because she prevented us from doing something.
You're cutting into my shout out time. You already said Ray, you already said Gary. I want to give a special shout out to Bridget, who was a volunteer at the 38th Songwriters Festival. I went over there yesterday for the day. My wife and I enjoyed some music outside. Bridget, you are the #1 volunteer at that event, and I thank you so much for the hospitality and for sneaking us into VIP. Appreciate that.
And Jen, next time we're gonna have mustaches on. Just letting you know.
Maybe. All right. Thanks for tuning in tonight. Again, we're here same time every week. LawCall, Perry and Young. Give us a call if you need help. Otherwise, we will see you next weekend.